Thank you, counsel. Justice Thomas. Justice Alito.
Counsel, our entry into the home cases, and it's been paramount that a person's home, we don't enter without a warrant except in recognized exceptions. And I understand the instinct that says that we don't want someone in real need not to have the police enter quickly, but we're always balancing interests, aren't we? And not requiring enough proof also costs lives. Petitioner cites reports that people with serious mental illness are 16 times more likely to be killed by police during a police encounter. An investigation found at least 178 cases in a 2-year period where calls for help, not a crime, like a 9/11 call or a wellness check, resulted in the police shooting and killing the people they were called on to assist. It's a fine balance, but shouldn't we make sure that the courts below are at least following the right standard? So you keep telling us that this state is, despite using words that sound very similar to reasonable suspicion, despite a case, Lovegren, that says it's less than a Terry stop. I mean, there's some value in clarifying what we have said the standard is. If you're asking us to describe what the quantum of proof, sounds like you wanted us to accept what the Solicitor General is saying. Some possibility is enough, but that's never been the standard. It's a reasonable belief, not a probable belief.
So I agree that clarification from the court, and I think the court can clarify that it meant what it said in Brigham City, it meant what it said in Fisher, and that an objectively reasonable basis is what it is.
And it's not reasonable suspicion.
It's not necessarily reasonable suspicion. I think in some
there's
cases,
the qualifier.
in some cases the standard can look like reasonable suspicion, and in some cases the flexibility makes it look more like probable cause. But there's where we're getting to the degree of certainty of the exigency. It takes it.
You want it to be reasonable suspicion.
Well, the objective reasonableness standard is the most faithful to the text, history, and tradition of the Constitution. If given a binary choice, we would take reasonable suspicion over probable cause. But objective reasonableness is much more flexible and faithful to the text, and it accounts for situations like this one or others where there is some doubt as to whether an individual is in need.
So we might as well just say what the court below said. It's less than a Terry stop.
Well, I think I'd look to the language in Fisher where the court says officers, of course, are going to have less than perfect information, but that doesn't mean they should walk away from potentially dangerous situations. And all we're asking is that they use their common sense. Officers, as well as reviewing courts, are more than capable of figuring out when the facts don't add up and when an objectively reasonable belief doesn't exist. And I think I'd go back to this court could apply whatever standard it articulates to the facts in this case to provide ample guidance to lower courts.